Hello, everybody. Thanks for joining us tonight in our continuing series of webinars. My name is Elliot Ruga. I'm the Policy and Communications Director for the New Jersey Highlands Coalition. It is unusual for an environmental organization to include in its mission the protection of historical resources. The New Jersey Highlands Coalition understands the value of connecting with our history. Understanding the development of our villages, towns, and cities provides us with a sense of place. Hidden in our built environment are the clues to the small as well as the epic stories that reveal to us who we are, how we got here, and why we stayed, or why we abandoned once vital settlements and vibrant industries now hidden in overtaking forests. Understanding who we are, how we got here, what we did, can also provide us with a better understanding of where we're going. An example of the values that historical resources can hold for us can be found in the Morris Canal and the contemporary initiative to create a recreational and heritage trail following the canal across the northern part of the state. The canal exemplified how we as an industrious people can overcome daunting technical challenges of the time in order to promote commerce and enriching the quality of our lives. It also connected growing towns, which became the ports and eventual New Jersey towns and cities. It also provides us with a physical connection, making our universe more accessible. And today we can connect to each other from the forests of the Highlands to the vibrant cities of northern New Jersey, such as Newark and Jersey City. Our guest tonight is well known in the New Jersey history community. Dorothy Guzzo has been the executive director of the New Jersey Historic Trust since 2008. Prior, Dorothy served as the Deputy State Historic Preservation Officer, where she oversaw the New Jersey and National Registers of Historic Places and implemented state and federal regulatory programs to protect New Jersey's valuable historical and cultural resources. Previously, Ms. Guzzo was employed by the same department as a grants and project manager overseeing the restoration and development of state historic sites. Resource types ranged from Revolutionary War battlefields, agricultural villages, and 18th and 19th century mansions, to lighthouse, ironworks, and sawmills. Combined, Ms. Guzzo has more than 21 years of government experience in historic resource stewardship. Guzzo previously served on the not-for-profit board of directors for the Crossroads of the American Revolution Association and ex officio to the New Jersey Historical Commission, New Jersey Historic Trust, and Main Street, New Jersey Board of Advisors, and was the past chair of the Alice Paul Institute. She has held elected office and served on her Municipal Planning Board and Local Historic Preservation Commission. Ms. Guzzo is currently serving on the New Jersey Heritage Tourism Task Force and charged with creating a heritage tourism master plan for the state of New Jersey. So welcome, Dorothy. Nice to have you here.
Thank you. So hello, everybody. Thank you for that introduction, Elliot. I have to tell you, introductions always make me nervous because they set up such a huge expectation. I just want all of your listeners out there to know that I'm new to webinars as a method for presentations, so I hope you'll cut me some slack. I'm very happy to be with you tonight. My presentation is an introduction to historic preservation, and I wasn't sure who might be in the audience. And since I can't see all of you, I don't know if you're confused by what I'm saying or if you're enjoying it or if you're laughing at the bad jokes. So please know that I'm happy to field questions either at the end of this, and you can always contact me via email anytime. So with that, I would ask Zach to put up my presentation. And you can go to the next one. I like to start at the very beginning when I talk about historic preservation, because I want you to understand the framework for how we preserve our important resources. The presentation that you're going to see tonight is very text heavy, and that's because you're all sitting in front of a computer and you can actually read the text, and it doesn't have as many pretty pictures as I might normally do to keep you awake at a regular presentation. But also, I also wanted you to be able to use it as a reference even after tonight. So there's going to be 3 words that crop up in the presentation throughout. It's called identify, evaluate, and protect. I'm going to begin, even though preservation begins much earlier, but I'm going to begin in 1966 with the passage of the National Historic Preservation Act. And this is very important because it created the National Register of Historic Places. It created the criteria for listing things. It also created the regulatory components of preservation. It required all federal agency participation in a process that we're going to get into in a little bit called Section 106. They also created the Advisory Council on Historic Preservation, which is an independent agency that is not within the National Park Service, but is there to oversee the regulatory process. It also created National Historic Landmarks, and I'll get into that a little bit more later on. And it came with money. Most important thing that this act in 66 did was it set up a federal-state partnership, and the state partner is the State Historic Preservation Office, and there's one in every state, and there's territories, and we then evolved to also have tribal historic preservation offices, and ours in New Jersey is located in the Department of Environmental Protection. Along with this, in the act, in a later amendment, it created the Historic Rehabilitation Tax Credit, which is an incentive for preservation, which I'll go over in a bit. Created a certified local government program, also an incentive, and the grants were set up to be a 60-40 split. That hasn't changed since the beginning. The feds are supposed to be putting in 60% of what it costs to do preservation, and the states are supposed to come up with 40%. Oftentimes in New Jersey, it's flip-flopped. Next slide, please. So in a nutshell, very quickly, I want to be able to help you understand how we do preservation and what the framework is. So as I mentioned, you have the National Register of Historic Places that was set up in 66, and it's administered by the National Park Service in the Department of the Interior. In New Jersey, in 1970, which was really ahead of its time at that point, we passed the New Jersey Register of Historic Places. So that's just 4 years after the National Act is passed. And that is housed in DEP. And that's kind of interesting because for some of you environmentalists know that 1970 is the seminal year when DEP was formed. And the Division of Parks and Forestry, the Historic Preservation, all of that is swept into that department. It's one huge department. And that's how it ended up in there because it's sort of following the same model as the National Park Service. The local designation process that I'm guessing most of you are most familiar with is done through a municipal ordinance, and it's administered through a local historic preservation commission. The national side of things, the National Register is mostly honorific. It doesn't carry a lot of teeth with it. What it does do is it helps you protect from federal government action, and it protects sites that are eligible for listing as well as those that are listed. We'll get into that a little bit more. In the state register, it protects you from state, county, and municipal government action. Some people thought it was a very invasive law when it was passed in 1970, but it doesn't protect private property owners. And in order for the state law to kick in, you actually have to be listed in the New Jersey Register. It doesn't protect eligible for. And then on the local level, that's where you can actually regulate private property. And we'll get into that later on in the presentation as to how that's done. So next slide, please. And that was just your quick overview. And the other thing I wanted to share with you is how historic preservation works in New Jersey. As I mentioned, there's a state historic preservation office. It's in the Department of Environmental Protection. It's in the Natural and Historic Resource Group. They administer the federal program. They're in charge of putting things into the state register, which then move on to the National Register. They are the state actors in the Section 106 and encroachment review. So those are the regulations. They are required to work with state and federal agencies. They run the certified local government program. They administer that tax credit that I mentioned. They're also responsible for identifying historic resources in the state. I work with the Historic Trust now. I used to administer that office, and the Historic Trust is basically the entity that has the money. So those of you who voted for that ballot initiative in 2014 to dedicate a portion of the corporate business tax to open space, farmland, and historic preservation, the preservation money comes to the Historic Trust, and we run the grant program. Just really quickly, we make grants to nonprofits, state, county, and local governments now. We also coordinate the annual conference, so we do some other things. We support educational initiatives. We also have an easement program, and we are heavily involved in heritage tourism at this point, and we are now located in the Department of Community Affairs. So New Jersey is always interesting. Next slide, please. Okay, so getting back to that National Historic Preservation Act, the first thing is, what is a historic resource? I told you I was going to get into some basic stuff here. And historic resources can be buildings, sites, structures, objects, or districts. And the thing to remember about a historic resource, there has to be some human touch to it. It has to be something that was created by a person. I used to say man-made, but I need to be politically correct. So now it's created by a person. Typically, a historic resource has to be 50 years old or older. We do have exceptional criteria. If you think about the Doo-Wop district in Wildwood, it wasn't yet 50 years old when we started identifying it as historic and understanding it and appreciating it. So there is exceptional criteria, but for the most part, it's 50 years old. Not everything old is historic, and that's sometimes a difficult thing for people to understand. You have to be significant in local, state, or national history. You have to demonstrate that significance in order to make a case for the register. And you must have integrity, and integrity is really, the resource has to be able to convey its period of significance, and that's sometimes problematical for things that haven't been fully evolved in the historical record, because they change and they're altered over time. And so sometimes they don't meet the criteria for listing. Next slide. So I first went to your website, and I do see that you have a map up there. So I encourage everybody to take a look at this. These are all of the historic resources that are located in the Highlands area. And I was blown away. Again, I mean, I knew this, but the Highlands region is just so big. And I was around in DEP when the Highlands regulations were first crafted. I had some input into the historic areas of that big piece of legislation. So I would encourage you guys, if you're looking for where your historic resources, this is a good map, and each one of those dots represents something, and there are historic districts represented in there as well. So next slide, please. Okay, so in order to be historic, you have to have significance. And the National Register, which is then adopted by the New Jersey Register, is an association with a historic event. Signing the Declaration of Independence would be a historic event. Association with an important person. We have a lot of those. When the register was first formulated, most of the things that got listed in the National Register were associated with 18th century people, signers of the Declaration, and people that were important in military history. And that sort of populated the register in the very early days. You can also be distinctive, have distinctive design or physical characteristics, and we think of that as being important architects. And there again, that's a very easy one to figure out if it's eligible for the register, because it still has its ability to reflect that original design. And then the last one is the potential to provide important information about prehistory or history, and that's usually reserved for an archaeological resource. And when I talked about integrity before, these are the items that you have to demonstrate in your National Register nomination. You need to have integrity of location. We typically don't like buildings that have been moved off to the original site. You can still be listed in the register if you're moved, if the reason that you're significant is solely because of your architecture, so that you should still be able to be eligible. There's a couple buildings in Cold Spring Village down in South Jersey, which is a collection of moved buildings, but there's still, the whole village is now listed in the New Jersey Register, but independently and individually, there were some buildings that were still eligible because what was significant about them was their early construction methodology that was still extant inside the buildings. Setting, another really important one. And again, a moved building has lost its setting. And typically when you move a building, we try and reestablish the setting that the building had to begin with. So you're putting context back to the building. Materials, Again, if there's been a lot of loss of materials, it may or may not still have integrity if it's all replacement materials. Workmanship gets back to the design of it and the construction, and then feeling and association, which is just kind of what we throw in there, and it's very hard to define. Next slide, please. So as I was saying, a site can be eligible. This one happens to be an ability to yield information in history or prehistory. This is the Black Creek site in Wawayanda. I should mention, though, there in archaeological sites, we try not to broadcast the locations of them because we're always afraid people are going to loot them, dig them, and that is against the law. It actually comes with penalties for looting off of a site that's protected, an archaeological site. But that would be an example of a site. Next slide. And these are examples of buildings. We have a mill building, we have houses, you could have a factory building. I tried to find things that were in the Highlands, which I think I hit it on this slide. I think we're good here. But this is also examples of things that are listed in the register. They all don't have to be this old. You can have things from the 20th century as well. Next slide. And these are examples of historic districts. The one on the left is the Little Falls Historic District. On the right, I was trying to capture the Morristown Historic District and Washington Valley. And districts are the collection of buildings. You can also have a cultural landscape. A cultural landscape is different from just a wide open space. A cultural landscape is something, again, that has had some sort of human construction to it, like you'll see a split rail fence or stone walls, or something that's cultural landscape, like 6 Mile Run, where there's a series of farm buildings nestled together. So that would be an example of like a cultural landscape, and that can be eligible for listing. A lot of the farmland preservation properties, a lot of the stuff that Green Acres is purchasing, well, the open space could fall under the cultural landscape category as well, and that can be eligible for listing. Next slide. And structures. This is the Stone Arch Bridge. I think this is the one in Bound Brook in Somerset, if I have this identified correctly, but culverts, things related to transportation. For any of you transportation nuts out there, New Jersey was the inventor of the rotary, the circle. We did demolish our first circle, but we did have one, and it was eligible for listing in the register. Grade separations, we were the first to do that. Right as you come off the George Washington Bridge, there's a very massive industrial grade separation, and that was found eligible for listing in the register. These things are structures. Yeah, so I was going to say lighthouses, but that comes on the next slide. Next slide, please. So then we have objects, and I tried to find a monument within the Highlands area, and I could not. So that's my limited knowledge there. I did find the Rutherford World War I monument, but I think Rutherford is right outside the Highlands, but I tried. And then we also have the more well-known, the iconic High Point Monument, and that's just examples of an object. Next slide. So as I mentioned, you have identification, evaluation, and that's tied to the National Register, and then we get into protection. And I'm sure a lot of you that are listening in here tonight have probably heard of the dreaded Section 106. And this was part of the National Historic Preservation Act, and it was the intent for the federal government to say that we shouldn't be ruining historic resources. If we think back to the 1966, the whole reason this act was created was because of the interstate highway system. The highway was being designed without any thought for the neighborhoods that it was running through. And so it was crashing into neighborhoods. And this was the uprising, and this was the result of that, was the passage of this act. And so part of a very important part of the National Historic Preservation Act was to tell federal agencies that they had to designate a historic preservation officer. And this is someone who's usually housed in the main office of whatever agency that they're in. And you can delegate the process down to a state who's doing the work of the federal agency, but the ultimate decision still lies with the historic preservation officer within the federal agency itself. So what the law says is that a federal agency is required to assess the impact of its actions on resources that are eligible for and listed in the National Register, or listed in the National Register. And this is really important because this is how we identify a lot of resources, historic resources, when there's something that's about to happen. the federal agency is required to go out and take a look and see if what they're going to do is going to impact any resources. The most important thing I want you to remember as we move forward in the Section 106 process is that it is a process and it doesn't prescribe an outcome. It basically, there's not some guru that says, oh, you're harming historic resource, you've got to stop, the federal agency can't do it. It doesn't work that way. It's really a prescribed process. It was set up and designed so that a federal agency will take into consideration its actions. A federal undertaking was defined as a project, activity, program, either funded, permitted, licensed, or approved by a federal agency. And an example of that is a cell tower. So the federal government's not actually constructing those cell towers, but they are licensing them. So anytime a cell tower was going up, they were required to conduct a Section 106 review, and that's where you get into setting. So an undertaking, it can have an effect directly on a historic resource, or its effects can be indirect. And it can include activities, programs, any of the elements that are not previously considered under Section 106. So one thing to remember with that is for a cell tower, you can be in its view shed of a historic resource. And if the view around that historic resource was part of what made it eligible for listing, that would be an adverse impact on that resource. So kind of a complicated law. Next slide, please. It doesn't have any teeth, but it can certainly gum you to death. And that was told to me by a federal agency. If you've ever been to the grounds for sculpture, there's a sculpture there for anything. Any presentation you want to give, there's a sculpture that can relate to that. Next slide, please. This is the process. And again, I apologize for how little that is, but I know you're all sitting in front of your computers. But basically, it's a process that's set up to involve the public. And so the first thing that the federal agency needs to do is I tell you or create a plan for how it's going to involve the public. They have to establish what their undertaking is. They have to notify the State Historic Preservation Office. Again, create that plan. They have to identify who might else be a consulting party in their undertaking. Typically, mayors are automatically consulting parties when the federal agency is going to be doing something in a community. The other thing that it needs to do is to look at what the area of potential effect is for that undertaking. And that can be small. So let's just say the federal agency is just going to replace a culvert. That can be a very small area of potential effect because it's relative. Or if they're going to be doing something like a new road or a road repaving, that could be a very long area of potential effect, depending what's involved in that. I keep using the Department of Transportation. I should stop doing that. There's a lot of other federal agencies, but they have to define that area of potential effect. And it's within that area that they're required to identify historic resources. And that's how a lot of things have been identified in most states, is through this federal process. Once they do that, again, they're supposed to go back out and involve the public to get views from the public to see if they've left anything out or if the public also thinks there's other historic resources that are out there. Once that has been done, and if there are no historic properties in there, they can be on their way. They can have no historic properties affected as part of the Section 106, and they can go ahead with their project. But if there are historic properties within their area of potential effect, they are required to assess what those effects will do to the historic resource. And again, there's a place for public involvement, whether the federal agency is actually doing that or not. There definitely should be. And if the assessment is that there's no adverse effect, you can be on your way with your project. But if it is an adverse effect, they're supposed to work with the consulting parties and with the State Historic Preservation Office to find ways to avoid the adverse effect. And if that's not possible, to minimize the adverse effect. And if neither of those are, then they have to mitigate the adverse effect. And mitigation is usually codified in a memorandum of understanding, memorandum of agreement. And then if you can't agree, if you remember in the beginning, I said that the 66 Act also set up the advisory council. If you can't agree, then it's punted to the advisory council and they become not so much the arbiters, but they take control of the process and they look to see if everything's been followed properly. So the one thing to remember in Section 106, at the end of the day, the federal agency makes the final decision about whether the project's a go or a no-go. So even if the State Historic Preservation Office says you're going to have an adverse effect, you're going to demolish a building, and the federal agency says, well, it's in the way of a highway, we have to do this, or whatever the resource is, they can call the shots and do that, and then they can offer some mitigation. It is possible for the state to say that you haven't looked enough at ways to avoid this and get back into it. I just like to mention in Section 106, there's no preordained outcome. It's still in the hands of the federal agency. It's a tough one. Most of the early litigation that happened with this was all procedural. It was all about going back saying, well, you haven't followed that process. You haven't done an alternatives analysis. You haven't looked at all the alternatives to see if there was some other way to get to your goal without harming historic resources. So it's very complicated. It's pages long as a rule. The actual training class for this is over a day long. When I've done classes, I usually spend a whole night on Section 106 and go over various things because it's not that easy to understand, and it's very easy for federal agencies to sort of have their procedure and say, well, we've done all of that. The other thing to know is they can develop alternative procedures, and the advisory council can agree with alternative procedures. So that's another thing to be aware of as well. Next slide, please. So in New Jersey, so that's the federal part of this. But as I said, we passed a New Jersey Register of Historic Places in 1970. And that was also to create, there's a train going by my house like a block away. Of course, it's going by right now while I'm doing this webinar. I hope you can't hear it because it's blowing its whistle very loudly. So the New Jersey Register was to also create a permanent record of the area, sites, structures, and objects that are significant to historical, archaeological, and architectural resources or that have cultural value. And our criteria was adapted from the National Register. So they're almost the same exact list from the New Jersey National. There are some differences because of owner objections and whatnot over the years, but for the most part, if you meet their criteria for the New Jersey Register, you're going to go on to be placed on the National Register. The law also sets up the criteria for receiving and processing nominations. It has an interesting line in there that no state funds shall be expended for acquisition, preservation, restoration, or maintenance as a historic place unless it's included in the Register of Historic Places. And I think I may be the only person who knows that in the law. But I thought it was very interesting. It was something that was very much as part of the initial legislation when it was passed, was that if you're going to spend state money to restore a historic building, you really need to be listed in the register, because again, the register was bringing an element of protection, and it was a way of protecting the state's investment. So now the most important thing, and where people often come to crash into the New Jersey Register law, is the encroachment. The law stipulates that any state, county, or municipality shall not undertake any project which will encroach upon, damage, or destroy any site that is already included in the Register of Historic Places without application to and prior written authorization or consent of the Commissioner of the Environmental Protection Agency. And the commissioner shall solicit the advice and recommendations of the Historic Sites Council. So this is pretty important. And the major distinction between the New Jersey Register law and Section 106 is that Section 106 requires the agency to identify historic resources and offers the same amount of protection and process to a resource that's eligible for listing as it does for one that's listed. In New Jersey, the state law, in terms of its protection, only applies to resources that are already listed in the New Jersey Register. Very, very different. And the processes are very different to determine encroachment and then what happens with the encroachment. So the law also created the Historic Sites Council. Well, actually, the Historic Sites Council was created prior to the law being passed, but they've been subsumed by the law. They were created in 1967, shortly after the tercentenary. So next slide, please. So unlike the National Register, the State Register actually does have somebody who makes a final decision, and that's the DEP commissioner. And if the DEP commissioner says no, that this resource is too important and you can't do what you want to do because it's going to harm it, that's a no. And then the flip side of that is the applicant can take you to court. So very different than 106, which is a process and doesn't have an outcome in mind when it starts. in the state register. It doesn't mean that DEP can't side against the resource and overturn a decision of the Historic Sites Council, because the way this works in New Jersey is an applicant makes an application to the DEP through the Historic Preservation Office. They determine that it's an encroachment. They pass it on to this Historic Sites Council, which is a body that's appointed by the governor. They usually hold hearings, and they're in Trenton. They're day long. Well, nobody's in Trenton anymore, all remotely. But so they have a hearing where they listen to the applicant, present all of the reasons why they want to move forward with their project. They typically tell the council things that they've looked at that won't work for their project, ways to avoid, minimize, or mitigate come up again. And then the council determines whether the project can go forward, or it could go forward with a list of conditions. So oftentimes the council comes up with ways to mitigate. So every now and then a project comes up before the council, and the council says, that's just too much, and we're going to say no to this. From there, it's up to the DEP to either affirm the council's decision or to overturn the council's decision. And DEP has overturned the council's decision over the many years. There was a major court case when a group of citizens groups sued the DEP because they overturned it, and the court sided with DEP and said that the mere fact that it's coming back to the DEP commissioner for the final say, it's inherent that the DEP commissioner has the ability to look over everything about the project and not just the protection of the historic resource. So in the case that came up before the court, there were extenuating traffic situations that the applicant was trying to resolve, and DEP felt that if they sided totally on the side of the historic resource, that they would be creating a traffic hazard. And so the court basically said the DEP did have the ability to take in a broader view. And that was on a particular thing, but it seems to have governed how things move along in DEP since then, because there hasn't been all that much litigation on historic preservation matters. So next slide, please. So again, the encroachment is actually an adverse effect. They use the same words from Section 106. Upon any historic resource, it's already listed. And it is determined, it basically is using the Secretary of the Interior standards, which is also something that governs the Historic Preservation Office. They were developed by the National Park Service. They were adopted into the state register law, and it's basically the Bible. Most ordinances in the state of New Jersey, when you get to the local level, also adopt and adapt the Secretary of the Interior standards. Next slide, please. This is a heavy one, and this is the definition of the undertaking. This is interesting because has an undertaking any action by a government entity or their instrumentality? So again, if a developer is doing something on behalf of the government, meaning that they need a permit for what they're doing, it has the potential, not a zoning permit, but like I'm talking about on a state highway, for example, where they might need a permit to do a road cut or something. They would be then acting as an instrumentality. So any undertaking has the potential to result in direct or indirect effects on any district, site, building, structure, or object that's listed. An action shall be considered to have an effect when any condition of the action causes or may cause any change, beneficial or adverse, in the quality of historical, architectural, archaeological, cultural characteristics that originally qualified the property to meet the criteria for listing. An effect, again, direct or indirect, which, again, is hard for people to understand that, because it's like, well, I'm not demolishing that, but you're affecting the qualities that made it eligible to begin with. A lot of text in this slide, apologize for that, but I think it's really important because it is the fully fleshed out definition of an undertaking. I also thought it was interesting, this has been around for a very long time. Indirect effects include those caused by the undertaking that are farther removed in distance or later in time, but are still reasonably foreseeable. So that is always an area of, I think, up for grabs, let's just say. Next slide, please. So some examples. What is an undertaking? It's an acquisition, sale, lease, transfer of deed, easement, an agreement, or other form of permission allowing use of a registered property, cyclical maintenance, and alterations or relocation of a registered property. So if you think about, for example, a municipality that grew out of its city hall and it wants to build a new building, well, what does it do with its old city hall, which is listed in the New Jersey Register? They can sell that building, but they would have to come to the DEP with an application and say that we're building a new building. We don't have use for this anymore. And what 9 times out of 10, what the Historic Preservation Office would say is, we will agree to the sale of this building, but you must put an easement on the property, which will protect it. And it provides the same amount of protection with the new owners as it did when it was a municipally owned property. So they're passing on, as long as it's protected, once they're allowed to deaccession the building. Leases, a leasing of a historic building, if it's a public entity, it has to be reviewed as a potential undertaking. As I said before, relocation definitely is an undertaking. So the one thing that I wanted to bring out too about what is not considered an undertaking, and it's changes in local zoning ordinances, issuances of building or demolition permits, granting of zoning variances, and then housekeeping and routine maintenance. And routine maintenance is defined within the state register law. And this was important to call out because, a lot of times when a town is changing its zoning or revisiting its master plan, it may not be sensitive to historic preservation, but the change in zoning itself is not reviewable under this act. So we're not the arbiters of what local government is doing with their master plans, or this particular law is not the arbiter. This is not where this is supposed to be dealt with. So none of that comes in as an encroachment application. Next slide, please. So now we get down to the local level. There's Municipal Land Use Law. It's the state enabling legislation. It's probably what most of you are most familiar with. Every town is required to have a master plan. It does get looked at and revisited and revised. It used to be 6 years, but I'm not sure that that's still 6 years anymore. Actually, in the master plan, they're only required to have 2 elements, but there's a whole list of other things they can describe in the master plan. Historic preservation is optional, and the planning board is typically the keeper of the municipal master plan. You can have a historic preservation plan element, and again, getting back to the language, that's identify and evaluate. And that would identify the location and significance of historic sites and districts. Also talks about the standards that they're using to assess worthiness for the site or the district identification. And it's analyzing the impact of each component and element of on the preservation of sites and districts. So that's another really important thing that the historic preservation element is supposed to do, because it's supposed to work in tandem with the rest of the master plan. You cannot protect legally protect resources on the local level unless you first have this historic preservation element within your master plan. Next slide, please. The Historic Preservation Ordinance, again, identify, evaluate, and protect. The governing body creates the ordinance, appoints members. They can remove members for cause. It does say the word shall make provision in its budget and appropriate funds. I like to say that because a lot of municipalities don't do that. And the municipal attorney is identified to serve as the attorney for the Historic Preservation Commission. And that is done because in the event that there's a challenge to a decision by the HPC, it moves up to either it's a recommendation to the planning board or it's reviewed appeal to the zoning board. You can't have the same attorney representing both. So they distinguish that it's a municipal attorney. You can also designate a separate, completely independent attorney to serve as the Historic Preservation Commission. The commission itself can have 5, 7, or 9 regular members, not more than 2 alternates. It's divided into Class A, B, and C. Class A is the ones that's knowledgeable in design and construction, and they can reside outside of the town because it was recognized that you may not have that expertise readily available or available to serve on the commission. Class B is knowledgeable with demonstrated interest in history. They also can reside outside the town. And a Class C are citizens. They don't hold any municipal office, but they can be on your planning and zoning board. And that's a good way to have an integration between how the boards are operating. Next slide. So I'd like to talk about the responsibilities of the Historic Preservation Commission, because many of them are just doing regulatory work, but in the Municipal Land Use Law, they do have a lot more things that they can be doing, which I think would always be beneficial, because education is definitely a part of what they should be serving in their community. First of all, they're identifying the historic resources that they want to protect. They can make recommendations to the planning board on the historic preservation element, and also the implications on historic property of any of the other elements that are adopted by the planning board. They can advise the planning board on the inclusion of historic sites in the recommended capital improvement program. They can advise the planning board and the zoning board on applications for development. They provide written reports to zoning on provisions impacting historic preservation, and they can carry out such other advisory, educational, and informational functions as will promote historic preservation in the municipality. So these are all things that are within their purview, and they don't all function that way. There is sometimes a lot of dysfunction with local commissions, because it gets back to the municipality appropriating funds. If you have a commission that's meeting and they don't have some guidance out there, particularly when they're first getting started, it could be difficult for them to understand all of the things that are in their purview that they really should be carrying on. I can get into, if anybody was interested in the questioning about the different types of commissions, whether you're regulatory or whether you're advisory to the planning board, and what the implications of that means, but that would really be getting into the weeds. And I think we probably, judging by all these pop-ups I'm seeing on my screen, I think we want to leave some time for questions in here too. So I'm going to leave it at that. So next slide. So I know there was a confusion about the word landmark. And as I mentioned in the very beginning, the 66 National Historic Preservation Act also created the National Historic Landmark Program. And that is a subset of things that are nationally significant and have a much higher threshold than just being listed in the National Register. Unfortunately, at least from a preservation perspective, the word landmark is picked up in the Municipal Land Use Law. And locally, the word landmarks can substitute in any ordinance, resolution, determination, or official action pursuant to the Municipal Land Use Law for historic preservation, and historic site. I have trouble with that, because I always think of landmark as being a national historic landmark, which is only about 2% of all the listings in the National Register. When you use the word landmark, though, in New Jersey, it can mean local landmark, and that's perfectly fine, perfectly accessible, and it's in most of the ordinances that are in existence in New Jersey. Next slide, please. So basically, again, pulling from my grounds for sculpture, it does take a lot to protect historic resources, because there's a lot of misconceptions about how you do it. And in order to do it, you have to really get down to the local level, where you can find the most resistance to wanting to do this. Is in order to pass an ordinance locally, typically if there's a lot of public objection to that, the municipality doesn't go forward with it. So I just threw this slide in there to show you that we're already, it takes a lot to do battle for protecting historic resources. Next slide, please. So benefits of historic preservation. Since this was a 101, I did want to point out, and again, this is a whole lecture, and actually I think we did a whole day's worth of a workshop at one point in time. Benefits can be heritage tourism, federal investment tax credit, and community pride. So let's go to the next slide, please. So the economics part of this, there is an economic guru in preservation world named Donovan Ripkema, and he's written all of the books on the economic benefits of preservation. He was the earliest in the field that was talking about, if it doesn't make economic sense, it doesn't make historic preservation sense. And he's come up with this definition here about teasing out the economy, the careful management of wealth, resources, avoidance of waste by careful planning and use, thrift or thrifty use. To economize is to use or manage with thrift or prudence, to avoid waste or needless expenditure to reduce expenses. And economics, the science that deals with the production, distribution, and consumption of wealth, and with the various related problems of labor, finance, taxation. And then this definition of historic preservation juxtaposed to this: the careful management of a community's historic resources, avoidance of wasted resources by careful planning and use, The thrifty use of those resources, to use or manage those historic resources with thrift or prudence, to avoid their waste or needless expenditure, to reduce expenses through the use of those historic resources. And he does this to really juxtapose this idea that for those that think historic preservation is for the elite, or that it's too expensive, too costly to preserve these things, that managed properly, it's totally in line with being economically viable. Next slide, please. One of the other ways to look at, and again, we could spend a lot on economic benefits of this, but another way that's, I think, easier for people to understand is heritage tourism. We did a economic impact study with the Historic Trust, took the lead in this a number of years ago, which talked about the economic impact of our resources in New Jersey. And this, again, was the first time this had ever been looked at, and people weren't really collecting the data. So it's likely if we did this again, we would see a much higher number, as long as we could take out this past year when a lot of things were closed. But essentially, historic resources were 8% of the total state's tourism industry. And that's a huge chunk of money, particularly for an industry that gets very little marketing. We don't market our heritage much to out of state, not like Virginia does, or even Pennsylvania for that matter, or a lot of other states that market their history. We have 11 million visits to historic resources. 2.8 billion is generated in visitor spending. Our history supports 38,000 jobs. And probably the most important thing is we generate $715 million in federal, state, and local taxes. And that was really important because at the time that we did this economic study, we hired the same firm that the state hires to do the tourism study and to calculate the economic impact of the big tourism picture in the state of New Jersey. So we did that on purpose because we wanted to make sure that they couldn't poke holes in this. So it was done very professionally. Next, it probably needs to be done again. So you really need to update this information every so often. So one of the biggest boons to preservation was the creation of this federal investment tax credit. It provides a 20% credit to a developer who is an income producing property who is redeveloping that property. It must be listed in the National Register at the date it's placed in service. The project itself must meet the Secretary of the Interior standards, the basic preservation standards. And the 20% credit can be taken over a 5-year period. In the latest tax law changes that were just done in like about 2 or 3 years ago, there was a credit for 10% credit for buildings that were just older than a certain period of time, but weren't necessarily historic, but that was eliminated. The tax credit, when it was first invented, used to be, or first passed, was 25% credit, and it was reduced back in 1986 when there was another overhaul of the tax structure. But essentially, this one program has been responsible for diversity in the National Register. A lot of the buildings that got placed on the register because developers wanted to redevelop them were industrial buildings, things that never would have been listed on the register unless someone could come up with a viable use for this. It's also responsible for the resurrection of traditional trades and craftsmen. I don't know how many people can think back to the 70s, to our throwaway mentality, but there weren't a lot of people around who knew how to rechain a window or reglaze a window or to do masonry repointing, brick repointing. All of these things we sort of had to relearn, and now they become commonplace. The tax credit is also responsible for cleaning up brownfields because the cost to do cleanup is also something that you can take the credit on. And it has engaged the development community in reuse, which was very, very important because I think before this, preservation was seen much more as a historic house museum type thing and not so much as a place where you actually live and work. So the tax credit really was good at spurring this. There are not that many projects that get approved for tax credits these days. It's a very rigorous review process. It's administered by the State Historic Preservation Office. There's 3 parts to this. The first being to establish the building's worthiness. Can it be listed in the National Register, or is it already listed? In the second part, you tell us what it is you're planning to do with the building. It has to meet the standards. You take a lot of photographs. And then part 3 comes in, and that's, did you do what you say you were going to do? And it's a 2-part review. It gets reviewed in the state office. It gets reviewed by the National Park Service, who then renders the final decision. And there is an appeals process if they turn the project down. And it's usually the credit is, the credit can be taken against passive income unless you're a real estate investor. So it did get limited when they put in the tax law changes in '86, but it's still out there. It's still very useful. And it's still the only thing that's keeping a lot of our challenging buildings standing, is because of this tax credit. Next slide, please. So just recently, New Jersey passed its own state tax credit, and I wish I could tell you a lot more about this, but I don't know yet. So I put this commercial in. Preservation New Jersey, which is the statewide advocacy organization, is going to have a talk with Tim Sullivan, who's the executive director or the CEO of the New Jersey Economic Development Authority. And we'll learn all about this. The governor has just signed the bill. It was an omnibus bill, has a lot of other economic incentives in it, as well as the credit for historic preservation. And I think they still have to pass the regulations for how this is going to work and how the EDA is going to work along with the Historic Preservation Office. So I would encourage people who are interested in this, because I'm going to tune into this in February to find out how it works. So I can't tell you about it, but I can just tell you hot off the presses, it just got passed. Next slide, please. So a little bit about where the money is to do these kinds of things. I had mentioned in the beginning that one of the things the federal government set up was the 60-40 split with the state. They provide 60% of the funding. The state comes up with 40%. They also tell the state that they need to withhold 10% of the money so that they can re-grant it to certified local governments. So this is a program that's administered with the Historic Preservation Office. And essentially, if you pass an ordinance, you can submit it to the Historic Preservation Office, and they will review it to determine whether it is consistent with the Municipal Land Use Law. And then if you are certified as a certified local government, you're eligible to apply for some of this federal funds. And that's the one, for a long time, that was the one major incentive for that. There's also a certificate program that is being limping along with Rutgers out of Camden, geared towards commission members and others that are interested in doing preservation and working at their historic sites. We have usually done a commission training class in March every year. It was canceled last year because it was right when everything was happening. And it's going to have to get resurrected because it is the one place where local commission members can get training. The Historic Trust takes the lead at planning the annual preservation conference. Again, we postponed last year's. We've decided we're going to do it this year, probably somewhere around the beginning of June. We're going to do it virtually. So we're exploring right now various platforms to do the conference. And we had already selected sessions to do. So we're reaching back out to panelists to see if everybody is willing to do the conference virtually, either pre-recorded or live presentations. So watch out for more information on that. So in the beginning, Elliot mentioned that I'm now working at the New Jersey Historic Trust. And we give out money. I mean, that's essentially what we do, as well as some other things. We have planning grants. We will make grants to municipalities or counties if they're looking at doing a historic preservation element or a historic preservation ordinance, something like that. Our smallest grant is up to $50,000 for a planning grant, and that's a 3-to-1 match. So for $50,000, you'd have to come up with $16,000. Again, we'll fund survey, master plan, ordinance, National Register nominations, historic structures reports, cultural landscape reports, condition assessments. If you don't see what you're interested in doing, by all means, contact the office and see if it's something that we would be willing to fund. Our next deadline is April 29th. We just announced our next round, and our eligible applicants could be a municipality, county, state, or a nonprofit organization. Another place where there's money for preservation, obviously, is through the municipal budget. And then I understand Sustainable New Jersey may have some funding available too. Next slide, please. And some other resources for you is just telephone numbers for the Historic Preservation Office. There's an organization known as the National Alliance for Preservation Commissions, another good resource for how to do preservation locally. There's obviously the National Trust, and then the National Park Service. There's a ton of information on the National Park Service website for preservation things. I think that's it on my slides. So we also administer the Discover New Jersey History license plate. And so I can't leave a program without doing a commercial for the license plate. We give all the money that comes in is re-granted out. We're funding heritage tourism. It's a small grant. It's a $5,000 grant. And it's really to foster heritage tourism, getting sites ready for visitors. And again, all the money that comes in for the license plate is given right back out in terms of a grant. And so we're always trying to encourage people when they're selecting their license plate to look at ours. And the next slide. And now I'm happy to field questions. And I saw a lot of pop-ups there while I was talking. So I think we are going to have some questions.
We do have several questions, Dorothy. Thank you so much. That was a lot of information.
Yeah, it was.
For a period of time. And just so people know, and this was in response to a question, this webinar, as well as all of our webinars, are on the New Jersey Highlands Coalition YouTube channel. Just search New Jersey Highlands Coalition and give us a couple days to maybe clean this up a little bit, and we'll have it up there so people can see it on demand on their own time. Couple of simple questions, and I'll get some more complex ones. There was a slide with a white horse with a Viking-looking character. Can you tell us what that was and where that's located?
Okay, so that's a sculpture. If anybody's been to Grounds for Sculpture, as you're driving up to this is in Hamilton, right outside of Trenton. It's a huge museum site, and it's all sculpture. But as you're driving to the place, there's these huge sculptures that pop up alongside the road. And one day I saw it, and I stopped the car and ran out and took a picture of it, because to me, it just epitomizes, you know, the difference between the federal regulations and the state regulations, that the state really does have an arbiter and a person who can say no to things if they're harming a historic resource. So that's the charge. What the specifics are of the sculpture, I don't know. It was snowing that day. I just took a picture. But it's Grounds for Sculpture. It's still there. I'm pretty sure it's still there. It's right near the railroad track, where the railroad comes through.
In Hamilton, I believe. Right?
Yep, Hamilton.
And who's on the Historic Sites Council? Are they gubernatorial appointees?
Mm-hmm.
What sort of background do they have?
So they're gubernatorial appointees. However, all of them are somehow involved in preservation. There's typically preservation professionals. There can be engineers on there, architects on there. There could be people from their local historic preservation commission, people with an interest. All of them are usually dyed-in-the-wool preservationists. It's very rare to have anybody on there who really isn't like found preservation. It's a very serious group of people. They meet several times a year. Usually their meetings run almost all day. And I give them a lot of credit, because all they see are the encroachment applications. They're not giving out money. They're not doing any of the happy stuff. They're really seeing people that are mad because they have to appear before them. And they do a really good job at trying to sort through all of the issues on a project and to work to find ways to avoid the harm to historic resources. And if that's not possible because of safety reasons or whatever, they do try and look for ways to minimize that activity. Sometimes it's a very, it's always, testy. They're always in conflict. It's a very difficult board, and I give them a lot of credit for doing that, but they are doing yeoman's work. And they make a recommendation to DEP. So what they say is not final. It comes back to, it's typically done by the Assistant Commissioner of Natural and Historic Resources, unless it's really politically hot, and then it gets pumped up a little bit higher.
Gotcha. So what obligation does Jen asked this question? What obligation does the state has if it owns a historic property? She recalls the egregious example of the Cooser mansion near Point. When it was first obtained with fundraising and grants, volunteers, it was very viable, but it was left in complete disrepair, and eventually it was demolished. And same thing with the Kirkbride building at Greystone.
Mm-hmm.
That was a county-owned facility, had great historic resource values, but in the end, it was demolished.
So those are two different scenarios. The Division of Parks and Forestry has just blossomed in acreage and resources, but their staffing levels hasn't blossomed, and neither has their financial resources. So while they've taken on a lot of responsibility, the resource side to take care of this stuff hasn't kept pace with this. And I feel like I can talk about this because I used to work for the Division of Parks and Forestry, and I was working on the state-owned historic sites. There's a collection of historic sites that have interpretive specialists at them. They're interpreted for the public. They're open to the public. And that's sort of gets more attention. And then there's a whole lot of historic resources that the division owns by accident, and it's harder to allocate funding for them. And it's a big problem, but it's really a resource issue. It's not like anybody sitting around saying, let's just let this rot. That's not happening. It's just really, where are you going to put your dollars? And typically they go towards things that the public is going to get the most benefit out of. Not a good way to do it. Greystone is a completely different issue. I'm very sad about Greystone because the trust helped pay for a financial report to talk about if the building was viable and could be saved and what kind of uses there might be for it. And basically, one of the results that came up in there is if the state took the money they were going to pay for demolition on that building and put it towards a tax credit as an incentive, that building could have been RFP'd, and there could have been uses for that building. There were parts of that building that were completely solid. I mean, they let it, a lot of the roofing go and water pouring in, but they did do an analysis of it, looking at various uses, and the building it was usable. I mean, it really was, but the state had this idea that they didn't want to put another penny into it, even though they were paying hundreds of thousands of dollars, if not millions, to demo it. So it was a really sad thing. And I believe that Greystone came down because there was another faction that just wanted a park, period. They just wanted open space there. And I think that's really what was behind it, because as a resource, it was reusable. They could have done a partial demolition too. And it's done it. It's such a sore point with me, because I spent years trying to get the state to understand, and also using it to try and leverage the whole, we need a state tax credit. If we had a state tax credit and you looked at that as part of its capital stack, along with the federal tax credit, this could really have been a little gold mine. But there were some other issues in terms of landlocked and roads, traffic, things that might be generated by a redevelopment proposal. There were other things that were weighing into the decision as well, but it was a really tough one to swallow. Let's put it that way. I don't think I've gotten over it yet, actually.
So can Historic Preservation Commission advocate? Can it rally public opinion? Can it advocate for a particular project, or do they have to remain neutral?
So you had a lot of stuff in that sentence you just handed me. They can advocate for good historic preservation in the community level. They cannot advocate for a project. That would be conflict, definitely. If they're involved in a project in any way, shape, or form, they should recuse from the application review. They should leave the room if it's being reviewed. They shouldn't be doing that. If they have some sort of relationship with either the applicant or who's ever presenting that would be considered a conflict. But in terms of the word advocacy, if you're promoting preservation in the community, you're offering workshops, talking about the historical significance in the community, that's all stuff that's part of their purview. So it really depends on, when you're saying the word advocacy, what you're actually, how you're actually talking about it. Oftentimes communities gel over a building that's proposed for demolition, that's threatened, and then trying to figure out a way to save that building. And it's difficult because oftentimes these are privately owned buildings. Yeah. So that you can't really apply some of these laws to them. I don't know if that helped.
Well, it's a complex situation. An HPC is a body of the municipality. Mm-hmm. It has to be consistent with the ethos of the town. Mm-hmm. I suppose. If a property is listed for, if it makes the register, let's say, does that protection eventually expire, or is it permanent? Can it be delisted?
So a property can be delisted from the New Jersey Register, but it has to go through the exact same process that listed it in the beginning. And the only way that it would come off the register is if there was like a fire and it was destroyed, or some other thing has happened to it to destroy the qualities and the characteristics that made it eligible for listing in the first place. You can't just wake up one day and decide your municipal building, you don't want it on the register anymore, so you want it to be delisted. Because if you do, you have to make the case for it. And you have to justify why. So, and that has to go through the exact same process back through the state review board to determine if, in fact, the building's lost that much integrity that it no longer meets the criteria for what listed it to begin with. So it's a heavy-duty delisting process, actually. Less so for the National Register, but definitely there is a place in the New Jersey Register for that, and it's a process like anything else. It doesn't just happen automatically, and you can't just say I don't want to be on the register anymore.
Right, right. Something has to impact its integrity.
That's right. Mm-hmm.
Does anything protect private property, either indirectly? Or, I guess not directly. Is there any strategies that can be employed that could compel a private property owner to respect or to preserve historical elements of private property if there's no undertaking?
So with private property owner, it's tough. So the only way you can protect that is by passing an ordinance. And that's oftentimes communities don't pass it because there isn't a consensus within the community. They don't want to be told what to do. They don't want somebody sitting in judgment. In terms of incentives, really what gets down to it is really a community pride, a sense of history in the community. One of the reasons that I like the ordinance, part of that is because if you do have a collection of historic buildings and preservation-minded people move in and they start working on their house and they do restoration, but their neighbor next door to them couldn't care less about preservation and there's nobody compelling them, and they do lots of things harmful to the building, that's harming your own property value. So if you're putting money and energy into your house to make it historically pretty, and you're trying to do everything correct for the building, but your neighbor isn't, and you're not protecting your improvements to your property are not going to be worth as much. That's something I grapple with all the time because I have a bungalow and I'm trying to do everything correctly, but we're not in a historic district. And so my neighbors aren't necessarily preservation minded. So I'm always grappling with that myself, but that's one of the reasons to do it. But since there are no actual financial incentives to doing your house, like you don't get a reduction on your taxes, there's no grants for private property owners. There aren't a lot of incentives other than through this idea of protecting property values as a whole within a community.
Right, right. How about, are there any incentives for private property that has historic resource values to recognize it through either the state planning process, state development and redevelopment plan, or the Highlands Regional Master Plan that would encourage private property owners to do something to protect the historic resource value of private property?
You're looking for like incentives built into some of these other things. I'm not aware of it. Is there something with the Highlands? I don't remember that being part of it.
Well, for the Highlands, it's entirely voluntary. If they want to, there is support if they want to follow a historic resource program, and there are some incentives, but there's nothing compelling for a Highlands municipality to participate.
Right. Yeah, I'm not aware of anything more than, I'm really not. I can't think of any other incentives that would be out there to do this. Usually it's a community that decides on its own that this becomes important to its identity and something that they want to pursue.
Okay. So the State Historic Preservation Office, because of something that occurs, they either come up with an opinion. I guess the lowest level of recognition of historic resource value is an opinion,
right?
And above that is a certificate of eligibility.
Hmm.
What's the difference between an opinion and what does an opinion provide?
So a SHPO opinion is basically information that's been provided to them for evaluation, and they've determined that it's either eligible or not eligible. When the Section 106 process is beginning and the federal agency comes to them and says, within our area of potential effect, we have found these three properties which we think are eligible for listing in the register, and the SHPO opinion will be written at that point saying these properties are eligible, and then that will be documented and put into their list. Certification of eligibility is oftentimes, well, is required for our grant program. So if somebody comes into our grant and they want a grant for a property, but it's not yet listed, but they intend to get it listed, the first thing they do is they go to the SHPO to get them to write a certification of eligibility. So SHPO looks at it and says, based on what I'm looking at, these photographs, the history you're telling me about, this property is eligible for listing in the register under this criteria. And so that will get their grant application in the door, that before we can spend construction money on that property, they would have to be listed in the New Jersey Register. So the opinion is kind of equivalent to, in the federal process, eligible for listing. The opinion is like it's eligible for listing. And the certification is a much more formal process. And again, it's usually used for a purpose, like our grant program.
Right.
Same thing, though. It's kind of the same thing.
But for, let's say, a designation of an historic district, there can be opposition to that.
Correct.
But is there opposition to a certificate of eligibility or an opinion by the SHPO that this is has historic resource value?
So an opinion doesn't carry any regulatory weight in the New Jersey Register law. So basically, it would just get documented as an opinion. Same thing with the certification of eligibility. It could also be used if there was a National Register nomination that went to the National Register and it had owner objection. The National Park Service wouldn't list it. They don't recognize government owner objection, but if it's private property owner, or if the majority of people in a historic district object to listing, it won't get on the National Register. But what they'll do is they'll turn around and write a certification of eligibility that basically this is eligible. However, we're not, because of owner objection, we're not listing it at this point.
But the COE may qualify it for grant funding?
Yes, but they have to get listed before we'll actually give them money.
Gotcha.
Yeah.
How frequently does the DEP commissioner make a decision of how frequently does it come to the commissioner's desk to render a decision about the historical value of the property?
So that's really relevant to who the commissioner is. When I was working at DEP, under the various assistant commissioners that I was working with, the commissioner really didn't get involved unless it was really, really, really big project, politically hot, people calling him about it. The commissioners usually didn't get involved. However, that changes because different commissioners have a much more hands-on way of doing things and like to know. So it's really it's not a question you can really answer because it's really dependent on the parties that are there. It's also dependent on who the assistant commissioner is too, and how much they elevate versus, take their own responsibility for. So it really, the decision is delegated down from the commissioner to the assistant commissioner, but that doesn't mean that the commissioner doesn't weigh in.
Gotcha. Well, that's all of our questions tonight.
Okay. Now that I've overcome this whole webinar thing,
Yeah. Oh, I'm glad we were the ones who forced you to overcome it, and maybe we could do some more work in the future.
Sounds good. Well, thank you so much for having me. This was great. It made me think about all of this stuff all over again. It was terrific. I'm sure I've just sort of virtually met a whole bunch of new people I didn't know before. So yeah, that nobody should feel free to get in contact with me if you have questions. It's fine.
Okay. Well, thank you, Dorothy. Thank you, everyone, for joining us tonight. Again, this is the New Jersey Highlands Coalition, and we really appreciate the Highlands' natural as well as cultural resources, and they are worth protecting. And we really like that we have crusaders such as Dorothy to help us accomplish that. So have a good night, everyone. We'll see you soon.